Hey everyone, it's Chase Elleby and Jared Easter at Williams Elleby, and we're going to talk to you today about loss of consortium. So as you know, we're personal injury lawyers here in Georgia, and with most personal injury claims, people always ask us, of course, if they're married, hey, do I have a loss of consortium claim? It's sort of like a buzzword that I'm sure if you've clicked on this video, you've probably heard of it before. So what does it actually mean? So Jared, how does Georgia define loss of consortium?
So loss of consortium in Georgia is defined as the loss of love, society, cooperation, companionship, and comfort of your spouse. Also kind of loss of services.
Right, so it kind of includes what you would think of like if you marry someone, just the everyday things that you rely on each other for. If you lose those due to an injury, and yes, it even includes that, which I know what you're thinking. If you lose that because of an injury, the spouse has a claim that's called the loss of consortium claim or loss of services claim, okay? So one of the key things, obviously, in order to bring this claim is that you have to be married. You have to be legally married. You can't be common law marriage. You can't be boyfriend and girlfriend who've lived with each other for years and years. You can't be engaged. It's strictly a marriage sort of there's strictly requirement that you have to be married to bring this claim. So, what is not included in a loss of consortium claim?
So they don't include lost wages, medical expenses, or other things you would miss out on. It's literally just the marital home, the idea that you miss out on, you know, your wife being able to clean or cook or take care of the kids. It does not include if your wife has to miss a day from work in order to take you to the doctor or, you know, something along those lines. Those expenses are not included in the consortium claim.
That's right. And it's also to think of it like, you know, we'll just do the classic married couple. If the husband gets injured and the wife is having to help pay for the medical bills and things like that, the wife isn't the one that can bring the claim for those medical expenses. It's the husband who incurred those expenses that brings that claim, even though if you're married, you know, everyone kind of shares equally in those sorts of things. But under the law, it's the injured party who brings the medical expenses. The spouse cannot bring the medical expenses claim. They bring the consortium claim. So speaking of, you know, sort of the claims, what can and can't be brought, under Georgia law, the loss of consortium claim is what we call a derivative claim, meaning that if there's no injury to one spouse, the other spouse doesn't have the loss of consortium claim, so it's derivative. So what does that really mean in a practical sense? Well, for the everyday sort of claim and things like that that we see, that means like let's say you have an insurance policy where there's a $25,000 limit per person per wreck, okay? So Jared gets in a wreck, bad injuries, is in the hospital, and it's easily $25,000 policy case, meaning the insurance company is going to pay $25,000 to settle his case. But Jared's wife also has a claim for loss of consortium. Well, because the claims are derivative, meaning her claim stems from Jared's claim, it's all going to fall under that one $25,000 insurance policy. So it's not two separate claims under two separate, I guess, areas of the insurance policy if it's loss of consortium. They're derivative, so it's one claim. So I know that kind of gets a little meaty, but just keep that in mind that a consortium claim, you can't have a consortium claim without an actual injury claim to the other spouse. So Jared, if I wanted to bring a lawsuit for loss of consortium, how long do I have?
Actually, you have 4 years, which is different from the normal personal injury case in Georgia, which would be a 2-year statute of limitations, which also kind of links back to that derivative injury claim issue. You have 4 years to bring the consortium claim, but you only have 2 years to bring the injury claim. So theoretically, if I was to get into an accident, I would have 2 years to bring my claim, while my wife would have 4 years to bring her claim for the consortium. If I don't bring my claim in 2 years, she can't bring her claim and then tag in any of my medical expenses or lost wages, the things we talked about earlier that aren't included. So in short, you have 4 years to bring a consortium claim, 2 years to bring an injury claim, unless it's a medical malpractice situation, and strangely, the Georgia legislature has limited consortium claims to 2 years in the medical malpractice context. You do not get the 4-year window if your spouse is injured as a result of medical malpractice. It would just be the normal 2 years.
Yeah, that's right. So I guess sort of the next question is, when do we mostly see these types of claims, these loss of consortium claims? In theory, you could probably bring a loss of consortium claim in most all cases if you're married and one spouse gets injured, but in reality it doesn't happen. Typically see them in cases where there's significant injuries. Think of long extended stays in hospitals where you literally do not have any help from the other spouse. Think of situations where you have a paraplegic, quadriplegic, or someone that you're having to take care of for the rest of their life. Those are typically when you see the loss of consortium claims, because quite honestly, if you bring a claim to a jury and if Jared was in a wreck and he broke his wrist, his wife's probably not going to bring a loss of consortium claim because there's not going to be a whole lot that has impacted the marital relationship with just a broken wrist, right? So juries might be like, well, I mean, they got married till death do us part. I mean, he just had a broken wrist. We're not going to give the wife a ton of money for something like that. It's going to be more to Jared for his injuries and what he's lost, as opposed to the consortium claim. So, like again, we just see them typically in bigger cases in that regard. And then I guess finally the last question is, what is it worth? What is a loss of consortium claim worth? It's super hard to quantify. It's kind of like in our other videos that you've seen when we talk about pain and suffering damages. Loss of consortium is the same concept, meaning it's up to the enlightened conscience of a jury to decide what they think the value of those loss of services, companionship, society are in that specific relationship. And the way that juries can decide that is through testimony, right? What was it like, to see your husband every day having to get up and take care of him, feed him, all these types of things, right? So it's the stories and the impact that give the jury something to give a value to the loss of society or loss of services and the loss of consortium claim. Well, I think that about covers it for our discussion on loss of consortium. If you guys have any personal injury questions, please feel free to give us a call at 833-LEGAL-GA. Of course, as always, like our videos, subscribe, comment, share, all those fancy buzzwords so you can get the word out. And if you have, again, any questions or topics you'd like us to discuss, please put it in the comments, and we will see y'all next week.